and that took up more space into the well of the court. So something had to give, and it was either the judge's bench or the lawyers or counsel table. Since I suppose you got the short. All right, so we are on my civil docket. I am providing public access not only in the courtroom but also online. Just want you folks to know that. And we are here today. Looks like defendants Bruckman filed a motion for summary disposition. I reviewed the plaintiff's response. Defendants Courtroom and Cisco filed a response in support of that. Plaintiffs filed a motion to strike that initial response for seeking relief for those defendants without a separate motion. It looks like, and there's responses to that motion to strike, but it looks like defendants Courtroom and Cisco filed an amended response that maybe fixes that problem. All right, so let's have counsel state your appearances for the record, beginning with plaintiff.
Yes, Your Honor. Joseph Sias on behalf of Mr. and Mrs. Holderman.
Kevin Cleaborn, I represent Mike and Becky Bruckman.
Lawrence Hanson on behalf of Mr. Cisco and Mr. and Mrs. Cole.
Okay, and is Richard Reeves present? No, and is Doris Reeves present? Okay. Mr. Reeves is representing himself, filed a letter answer. It wasn't signed by Doris, so there was a default entered on her, but they are both improper. Okay, so Mr. Zayas, I guess my first question is, does the amended response address your concerns? And we're not going to hear argument about striking their initial response.
Only if, Your Honor, that the defendants aren't going to request summary disposition on their own behalf.
Well, I don't know, because I guess my other, and I don't want to jump the gun here to I want to hear argument from all sides.
Sure.
But if Bruckmans are entitled to summary disposition, wouldn't everybody? I mean, these are co-tenants.
Right. I mean, there are some similar issues. I understand that. My real issue.
Similar, how would they be any different? I mean, the court rule says if I conclude that the facts are such that a party's entitled to judgment, then I should enter it without delay. So if Bruckmans prevail today, it seems to me all the defendants would prevail today. Why would there be any difference if they're co-tenants?
My real issue with the pleadings that the Cleaborns filed, Your Honor, was the fact that they added additional arguments. In fact, even adding additional case 3 days before my response is due. If they simply filed a concurrence saying exactly what the court just said, I think it'd be a completely different situation. But when you shorten the time I have to reply by 2 weeks by adding additional arguments and even referring to another case, then I think that's a different matter. And that is my real issue with the Cleaborns trying to kind of add themselves onto this. It wasn't a simple, yes, we concur, us too. It was, here are these other arguments that why we should grant us summary disposition, which are not exactly the same as what the Bruckmans filed.
Oh, okay. All right. Well, and I know there was a response to your motion to strike, and so you all, or many of you, seemed to care a lot about that. I want to assure you, I cared very little about all the details of when it was filed and whatever. I read all this stuff. You all did a great job filing all this stuff. So I am much more interested today in the, you can make whatever arguments you want to make. I am much more interested today in the substance on whether the Bruckmans are entitled to summary disposition. And it seems like if they are, that's the first domino and everything falls after that. So that would mean it's your motion, Mr. Cleveland.
Thank you again. Good morning again, Your Honor. It seems like from the plaintiff's view of the world, they pled adverse possession, hostility, et cetera, time and time again. But the facts at their depositions just shout loud that there is absolutely no element of hostility whatsoever. And any kind of claim like that has to be inconsistent with the rights of the defendant. And so is there anything anywhere where the use of that drive was inconsistent with the rights of the defendants? And the answer is no. The issue of even the extension of that drive onto the plaintiff's property plaintiff Rich Holderman testified, well, I put that in for Mr. Covington's father, Grandpa Covington. He never said, well, I did it because I wanted to, I did it because I need to, or anything like that. The plaintiff, Julia Holderman, testified it was for the defendant's guests. And so even that extension of the drive onto their property from the upper level was not done under a claim of right. And so, you know, every case that's out there having to do with this type of prescriptive use claim has some kind of element of hostility, and there just isn't any. And so when we go back to the records that we attached to our motion, where the Bruckmans have records of gravel dating back to 1994, and then the plaintiffs have nothing. I mean, the only thing that they've produced with regard to any kind of documentary evidence at all is the purchase of an Argo and a Kubota side-by-side. And so it just seems to me that there's just nothing. And so when the plaintiffs admit, yep, we're friends and we do it all together, and they really have no comeback even to anticipating their best argument. Gee, we bought in 1984 in land contracting, so we were there before you. But when Mr. LeBron testifies, I put up a lock and cable while I was there for the 6 years, and I never saw the plaintiff using it at all. Again, there's no continuous hostile claim of right, 15 years, etc., that the plaintiff would have to establish to take away a property right of the defendants. And so, again, when I'm glad that counsel for plaintiff attached the deposition transcript of Julia Holderman. So at page 25 of the deposition, she testified when I asked her a question about, how does the whole gate kind of thing. She said, normally we'd ask them, meaning the Comptons, permission to open the gate. Can you please open the gate? We need to get down. Well, my goodness, there is no hostility at all. If they're best buds with a 1/4 owner of the tenant in common property, then again, there is nothing that the plaintiff has shown, even an iota of a claim of right type thing to take away a property right.
So can I ask you, in your motion, you spend a lot of, you spend some amount of space documenting the friendship over the years between some of the parties. And at first blush, seems the plaintiff in the response was making a fair point that the hostility element is a legal term and not a term of emotion. So maybe you can help me nuance that. You're not saying that because they were friendly, that defeats a claim of hostility, but that therefore it wasn't against their interest under a claim of right because it was a cooperative use. Is that?
Yeah. So the I think the case that they cited a couple of times, that Munro versus Riddle case, was their primary argument with regard to, well, gosh, the one owner of the property knew that the drive to the neighbor cut across the corner, and they didn't do anything about it. They never discussed it. They basically let it go. But again, that was not a case that they're relying on. That was a shared driveway issue. And that's right.
But you'd acknowledge that hostile use doesn't mean angry use.
No, it doesn't have to be,
Use.
it doesn't have to be in your face type thing, but it still, throughout every case out there, has to be inconsistent with the rights of the defendants in this case. And so, when there is, gee, we're having parties all the time, we're best friends, etc. And it just speaks to the volume of evidence that is on the defendant's side with regard to the permissive use. And again, the Munro versus Riddle case was just a corner of the property that was used exclusively or primarily by the neighbor. And that's why I thought that case was easily distinguished. The only thing that I could add to what I tried to provide to the court is with regard to our claim for summary disposition on the riparian rights issue. I finally found a bigger, better plat that's clear of Vincent's plat. I do have a copy of it I could share with the court. I had a really poor blow up copy, but here's the primary issue with regard to our trespass claim. I tried at Mr. Holderman's deposition to get him to appreciate the issue that the riparian survey was measured from the section line 105 feet. And so if you look at lot 15, can you see where there's a little arrow and there's 13.72 feet to the south of the
Yes,
section line? So that's where, again, I can't win a case of deposition. I just need to try to establish facts. And I finally raised the white flag and gave up trying to get him to appreciate that the riparian survey that we have prepared went 105 feet from the section line north to establish the fact that their dock was trespassing in the defendant's lake space. And so it's just a bigger, better, clearer issue with regard to what was the debate at his deposition of did their dock offend into the defendant's lake space or not. And then when counsel went ahead and argued, well, gosh, the dock isn't there anymore. I mean, everybody can see the dock that they've put back in. This year, they've since the lawsuit was pending, 24 and 25, they put the dock out, they put the shore stations out, they've got the stuff in the water that they always had. So to argue that, you know, it's not there anymore, it didn't make sense to me. I was really confused.
and your counterclaim, do I understand right, that's based on, well, here we've got this riparian survey and there's really no countervailing facts submitted by the plaintiffs other than saying they just disagree with it.
Correct, that's it. So, I mean, it was riparian surveys, as the court probably knows, are not cheap things. So we went ahead and had one commissioned in 2024. And again, the admission at their deposition was, yep, for the last 3 years, we've gone out from the same point just inside their property line and have angled out into the water. And so it just seems like, you know, it may be not tens of thousands of dollars worth of damages, but obviously when they trespass and put their dock on the bottom lands of my client, and then, you know, more boats on the side of the dock, it takes up more lake space. There is an element of damages to that. So I wish we would be all done here today, but I would ask that the court dismiss the plaintiff's complaint. And again, just set a hearing for our counter complaint for the riparian space intrusion.
Thank you. So I think in the interest of allowing a joint kind of response, I'd like to first next hear from Mr. Hanson on his concurrence and relief, and then I can hear from you, Mr. Zayas. Go ahead, Mr. Hanson.
Your Honor, you indicated that you read the response and the amended response that incorporates the additional arguments that I thought were perhaps useful. And
Yes, sir.
I would again just emphasize that the relationship, friendly relationship between the parties is a
That hearing had a little bit of everything. Holderman vs. Brockman et al. Was a civil property fight that turned into a crash course on adverse possession, co-tenancy, and even riparian rights, the water access issues that can make neighbours less than neighbourly. Judge Aaron J. Gauthier presided with his usual balance of patience and pragmatism, cutting through the procedural clutter and steering everyone toward the heart of the dispute. On the defence side, attorney Kevin Cleaver argued for summary disposition with confidence. His point was straightforward. The plaintiff's claims of adverse possession just didn't hold water, literally or figuratively. He leaned heavily on deposition testimony, where plaintiffs openly admitted they'd used the driveway and property with permission, even asking their neighbours to unlock gates when needed. That, he argued, is the opposite of hostile use, which in legal terms means use inconsistent with the owner's rights, not necessarily angry behaviour. Cleaver also pulled out documentary receipts, records of gravel and maintenance paid for by the defendants stretching back decades to show who had actually invested in the property. Intiff's counsel, Joseph Sayers, pushed back, pointing out that hostility, in this legal sense, doesn't require animosity, and that long use of property can ripen into ownership even among friends. He also raised concerns about fairness in the pleadings, noting that some of the defendants piggybacked onto motions with new arguments late in the game, shortening his response time. Judge Gauthier, however, didn't seem too interested in the procedural quibbles. He assured counsel he'd read all the filings and was far more focused on the substantive question. Was there any evidence of hostile, exclusive use over the statutory period? The DEF filled in a counterclaim about the lakefront. They'd commissioned a formal riparian survey showing that the plaintiff's dock and boat setup extended into the defendant's water space. Cleaver made a point of highlighting this as trespass, not necessarily a massive damages case, but one with real impacts on lake access. It was a clear pivot from dry property law into the kind of disputes that often spark neighbour feuds: docks, boats, and who controls how much water. Judge Gauthier Kiefer calm, even lightly dismissive of some of the procedural sniping. He pressed the lawyers to clarify whether the long, friendly relationship between families amounted to permissive use, fatal to adverse possession claims, or whether there was evidence of a true claim of right. His questions cut directly to the core issue, and while he didn't issue a final ruling in the transcript at hand, his tone suggested skepticism toward the plaintiff's theory. Overall, the session was less fiery than some criminal dockets, but it had its own intrigue. Long-standing friendships, decades of casual shared use, and the sudden shift to legal claims over land and water rights made for a layered dispute. And through it all, Judge Gauthier anchored the discussion with clear, methodical questioning, ensuring that the law, not neighbourly tension, guided the outcome. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.